Okay, let's unpack this. We are tackling a really bizarre life or death incident today. And it lands right at the intersection of extreme morality and cold, unforgiving contract law. Here's the basic idea. You perform a truly heroic act, you save someone's life, maybe at great personal cost, and the person you save promises you, you know, everything, a huge reward. Is that promise legally binding?
Yeah, it really feels like it should be, doesn't it? But the law, well, it often draws a pretty hard line, a line between a debt of gratitude, however strong, and an actual enforceable contract. So our deep dive today is focused entirely on one core legal concept. That's the doctrine of consideration. And we're using a classic, almost unbelievable case from North Carolina, Harrington v. Taylor, to model exactly how a court analyzes this. Is it a legal obligation or just a heartfelt but legally meaningless promise?
Right. Our mission then is to understand that bright line the law draws. So let's start at the foundation. What is the bedrock rule? The rule in contract law about consideration that determines if any promise can actually be enforced in court.
Okay, the foundational rule is pretty straightforward on its face. A promise is only legally enforceable if it's supported by consideration. But here's the crucial part. Consideration must be a bargain for exchange. And that's not just a phrase, it's a really rigorous test. It has two mandatory elements that have to be present right when the supposed contract is formed.
Okay, tell us about those elements. What exactly are we testing for?
So first, there needs to be some kind of legal detriment to the person receiving the promise, the promisee, or a legal benefit to the person making the promise, the promiser. But honestly, that's usually the easier part to find. The second element, and this is really the most critical one, is that this detriment or benefit must be reciprocally induced.
Reciprocally induced. What does that mean in practice?
It means the promiser has to seek that action, that detriment or benefit, in exchange for making their promise. And just as importantly, the promisee has to give that action in exchange for getting that promise. It has to be a two-way street, a mutual push and pull, if you will. If that mutual inducement, that bargain element, is missing, the promise just isn't enforceable.
Ah, I see. So it can't just be a one-sided expression of thanks or generosity that happens after the helpful act is already done. It has to be baked into the deal from the start.
Exactly. Think of it like this. Say I give you a brand new car for your birthday,
Yeah.
just a gift. And then later, maybe you feel grateful, and you promise to pay me $5,000 for it.
Hmm.
Your promise to pay. Totally unenforceable. Why? Because the gift of the car wasn't induced by your later promise. It wasn't given in exchange for your promise. It was already a completed gift. The law actually has a name for this specific problem. It's the past consideration trap.
Okay, the past consideration trap. That sets the perfect stage for our case then. Let's dive into Harrington v. Taylor. This came before the Supreme Court of North Carolina back in 1945. First off, what are the legally dispositive facts, the key facts the court focused on?
Well, the facts are, frankly, brutal. The defendant, Mr. Taylor, had assaulted his wife. She fled from him and took refuge in the plaintiff's house, Mrs. Harrington's home. The next day, Taylor shows up again and starts assaulting his wife once more. During this terrible struggle, Taylor's wife manages to grab an axe, strikes him down, and the court documents say she was on the point of cutting his head open or decapitating him.
Wow, okay, intense.
Absolutely. At that exact moment, Harrington, the plaintiff, intervenes. She throws her hand up to block the descending axe blade struck to save Taylor's life. She succeeds in saving him, but the axe blow lands squarely on her hand, mutilating it very badly.
A truly horrific price to pay to save someone, especially under those circumstances. What happened next, legally speaking?
So, subsequently, and that word is key here, after he was safe, after the danger had passed, the defendant, Taylor, orally promised Harrington he would pay her for all her damages, for her injured hand. And he actually did pay a small sum at first. But then he just stopped paying, didn't pay anything more. So Harrington sued him for the rest of the money he promised. And in response, Taylor demurred to her complaint.
Okay, let's pause on that word again. Demurred. For listeners who aren't lawyers, what does it mean when a defendant demurs? What are they arguing?
All right, good question. A demurrer is basically a legal move where the defendant says to the court, look, let's assume to the sake of argument that every single fact the plaintiff has stated in her complaint is true. Yes, she saved my life. Yes, her hand was horribly injured. Yes, I promised to pay her afterwards. But even if all those facts are completely true, they still don't add up to a legally valid claim for breach of contract under the law. They're essentially arguing that the plaintiff's own story, even if believed entirely, fails to meet the legal requirements for an enforceable contract. It's an argument purely about the law, not the facts.
That's a cold calculation, legally speaking. Okay. So given that demurrer, what was the core legal issue the court had to decide?
The precise legal question boiled down to this. Does a promise made after the fact to pay someone for damages they suffered during a prior voluntary humanitarian act, even one that saved the promiser's life, constitute legally sufficient consideration to make that promise enforceable?
Got it. And what rule of law did the North Carolina Supreme Court apply to answer that question? Could you state the full black letter rule and maybe break it down into its testable elements for us?
Sure. The court sided with Taylor and affirmed the demurrer. The rule they applied was essentially this. A humanitarian act, voluntarily performed, is not sufficient consideration to make a subsequent promise legally binding. And this rule really flows directly from those two elements of consideration we talked about earlier. The promise failed because it lacked both required elements.
So it failed because of the bargain for exchange element and something about the nature of the act itself.
Exactly. The court found the promise failed the test for two main reasons based on those core elements. One, lack of bargain for exchange, which is really about the timing. The act was done before the promise. That's the past consideration trap again. And two, lack of legal sufficiency, which is about the nature of the act. It was seen as a purely moral obligation or a voluntary gift, not the kind of thing the law recognizes as a basis for a contract. Let's call that the nature trap.
Thank you. Okay, now for the court's elemental analysis. This is where we see how they applied those rules. Let's walk through it step by step, element by element. How did the court apply that first element, the bargain for exchange requirement? What was their reasoning there?
Okay, so for the first element, the sub-issue is almost always timing. The court looked closely at the sequence of events. You have the life-saving act, Harrington catching the axe, getting injured. That happened first. Then later, after he's safe, Taylor makes the promise to pay. Because Harrington's heroic action, the thing she's offering as consideration, was completely finished before Taylor made his promise, the law slams the label past consideration on it. Since her action wasn't motivated by or given in exchange for Taylor's later promise, that critical element of a bargain for exchange just fails. The promise didn't induce the act.
Right, but I can almost hear the objection now. Someone might say, isn't this legal rule a bit harsh, maybe even cruel? I mean, she suffered a massive injury, saved his life. Doesn't the law ever recognize that some acts are just so incredibly valuable they should imply a contract, even if the promise technically came later?
That's the natural emotional reaction, and the court even acknowledged it. They understood the moral weight. But the policy reason behind the strict timing rule is really important for the stability of contract law. If Kurt started enforcing promises just because someone felt grateful for something that already happened, think about it, it would open the floodgates. How could you ever tell the difference between a genuine enforceable contract and just a sincere thank you or a promise to make a gift out of gratitude? The bargain for exchange requirement acts like a firewall. It's there to ensure, as best the law can, that both parties actually intended to strike a deal, an economic exchange, at the time the actions and promises were happening.
Okay. That makes sense. It puts the burden on proving that mutual intention for future action linked directly to the promise. Understood. Now, what about the second element the court looked at? The legal sufficiency, specifically concerning moral obligations or what you called the nature trap.
Right, the nature trap. This focuses not on timing, but on the kind of act Harrington performed. The court was clearly sympathetic. They even wrote that Taylor should be impelled by common gratitude to alleviate the plaintiff's misfortune. They recognized the strong moral obligation he had. However, and this is the key legal point, the sub-rule here is that common gratitude or a feeling of moral obligation, no matter how strong, is not legally sufficient consideration. It doesn't count in the eyes of contract law. The court explicitly characterized Harrington's rescue as a humanitarian act voluntarily performed. For a contract to be valid, the consideration has to be legal consideration, something the law recognizes as having economic value in an exchange, not just moral value.
So basically, because her act of saving him was pure altruism, something she wasn't legally required to do, and something Taylor didn't ask for or promise anything for before she did it. It just stays in the realm of morality, not law.
Precisely. You've got it. The law in this area is really concerned with transactions, with bargains, not necessarily with enforcing moral debts or rewarding heroism after the fact. Harrington had no legal duty to save Taylor, and Taylor offered nothing beforehand to induce her to take that risk.
Okay. So after analyzing both elements, the lack of a bargain because of the timing, and the act itself being characterized as purely moral or humanitarian, what was the court's final conclusion?
The court's conclusion flowed directly from that analysis. They held that Mrs. Harrington's complaint failed to state a valid cause of action. Why? Because Taylor's promise to pay was not supported by legally recognized consideration. Therefore, the lower court's decision to sustain Taylor's demurrer was affirmed. The bottom line: the incredibly brave life-saving act was, in the cold eyes of contract law, legally irrelevant to making his later promise enforceable because it happened before the promise was made.
Okay, wow, that's a stark outcome. Now here's where it gets, as you said, really interesting. Let's test this timing thing with a slightly different, visceral hypothetical. Imagine the exact same horrific facts. Taylor assaulting his wife. The wife grabs the axe. Harrington intervenes, catches the descending blade. But this time, imagine Taylor sees his life flashing before his eyes, sees Harrington's mutilated hand, realizes the danger isn't quite over yet, maybe the wife is still struggling, and he immediately screams right then and there, "Oh my God, I swear, if you just hold that axe for 5 more seconds while I get help, I will pay every single penny of your damages."
Now, if Harrington, bleeding, in agony, hears that promise and consciously does hold on for those extra 5 seconds because of that promise, does the analysis change?
Yes, the analysis changes completely, fundamentally. And this highlights the absolutely critical nature of timing. The facts are still gruesome, yes, but the legal dynamic is instantly transformed. If Taylor makes the promise before the act of saving him is fully completed, and, crucially, if that promise induces Harrington to incur further specific legal detriment, like consciously choosing to endure the pain and risk for 5 more seconds.
Exactly. Like holding on to that axe, ensuring the injury is fully realized, consciously bearing that risk for that extra time in reliance on his promise, then it's no longer past consideration. Her act of holding on for those 5 seconds is now directly bargained for.
Because the promise came before or during the final part of her action and it motivated her to complete it, it became reciprocal.
That's precisely right. Her continuing action, her endurance for those 5 seconds, is now arguably given in exchange for his promise of payment. The timing shifts it from an unsolicited past act of heroism, followed by gratitude, into a potential mutually agreed-upon exchange happening in the present moment. That scenario likely satisfies the bargain for element because the promise and the final increment of detriment happen concurrently, or the promise induces that final increment. That single moment, those 5 seconds of induced endurance, could be the difference between just a moral debt and a legally enforceable contract.
That really, really isolates the legal requirement. It's all about proving that the promise induced the action, or at least the completion of the action.
Absolutely. It's about demonstrating that link, that reciprocal motivation. And, to help you apply these rules, whether you're tackling a law school exam problem involving contracts or maybe just trying to figure out if a promise someone made to you holds any legal water, here's a kind of actionable diagnostic checklist. It synthesizes what we learned from Harrington and the hypos.
Oh, perfect. A framework. Please, lay out the steps for spotting these two traps, the past consideration trap and the nature trap.
Okay. Step 1. Identify the promise. Be really clear about exactly what the promiser offered to do. Step 2. Assess the consideration. What action or forbearance or return promise is the promisee claiming they gave in return for that initial promise? Step 3. Check for timing. This is the past consideration trap detector. Ask, did the promisee's act, the supposed consideration, occur entirely before the promise was made? If the answer is yes, then ding, 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 it's presumptively past consideration. And that means the promise is likely unenforceable because the past act couldn't have induced the later promise.
Okay, so that step alone immediately flags the original Harrington facts as problematic.
Correct. Step 4. Check the nature of the act. This is the moral obligation or nature trap detector. Ask, is the claimed consideration merely an act of kindness, family affection, basic gratitude, or fulfilling a pre-existing moral duty? Think about the life-saving act in Harrington. If yes, then the rule from Harrington likely applies. This kind of moral, humanitarian, or gratuitous act is generally considered legally insufficient to support a contract, even if the promiser felt genuinely obliged. And finally, step 5. Conclusion. If the consideration you identified falls into either the timing trap, it's past, or the nature trap, it's merely moral gratuitous, then the conclusion is usually straightforward. The promise lacks legally sufficient consideration and is therefore unenforceable as a contract.
Okay, so bringing it all together, what's the big takeaway here? It seems the law is pretty adamant that contracts are meant to be tools for, well, verifiable economic exchange. They aren't designed to be mechanisms for enforcing gratitude or moral debts, no matter how profound or deserved they might seem. We tried to give you that shortcut today, really dissecting this very unusual case and modeling exactly how courts think, element by element, about that critical difference between a moral feeling and a legal obligation.
Exactly. And, this does raise a larger, maybe more philosophical question that goes beyond just the legal rules. If the legal system is so strict, if it refuses to enforce even a debt of gratitude for something as fundamental as saving a life, what does that say about the role of altruism or spontaneous generosity within a legal system that seems primarily focused on transactions? What are the broader policy implications? Does this rule discourage heroism? Or does it simply keep contract law focused on its specific purpose? That's maybe something for you, the listener, to mull over as you encounter promises in your own life.